Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hello, welcome to the Wills and Estates Podcast with degroots.com.au. And today we've got a special session for Christmas time, dinner table promises. So as Christmas approaches, it's often a time when families come together, creating an opportunity for meaningful conversations about topics like testamentary intentions and plans for family businesses and death. What are some key things that people should consider when having these discussions? So today we have some new guests with us, and we have Danielle. Hello, Danielle.
Hi, Tony. How are you?
Fantastic. And hello, Jessica.
Hi, Tony.
All right, so I'm going to leave it up to you guys because there's two of you there, and we're going to have a chat about the topics that you want to talk about.
Okay, so like you say, we've got some key considerations that people should be thinking about when they're having these sort of dinner table discussions. So I know the importance of recording these promises that are being made is integral. That will help differentiate between the intentions of a gift or the intentions of a loan. And there are some other considerations that come along with that. So we've got, if, for example, we're talking about a loan. So if I had intended to loan some money or some property to my child, had that not properly been recorded and my child then passes away, it is the requirement that their estate pay that back. That may not have been my intention. So I might not have intended for their estate to have to bear that cost. And I should have documented it to forgive that loan on their death. That could have flow-on effects to their grandchildren or my grandchildren, and they will be receiving less than otherwise intended by me. On the flip side, if I was intending to give a gift, then that should also be recorded so that there's no questions down the line on the death of my child or me that was intended to be a loan. So my child's siblings, my other children could raise claims that the gift I'd given to one child was intended as a loan and therefore try to bring that back into my estate on my death so that their benefit is increased. There are other considerations for loans as well, such as interest and whether that should be payable, whether I want that payable, things like that to really think about.
And just to jump in there, Danny, one of the important considerations that we often find a testator or parties when they're having these discussions misses out is the importance of obtaining specialist advice. It's quite common that we will see families, especially after Christmas, having had the opportunity to have those discussions. They might come in and say, hey, we've already worked out the nuts and bolts. This is what we want formalised. And that might only be a one-way type engagement. It might be dad coming to us saying, hey, can you help us document this? Certainly we're equipped to identify any potential conflicts, but often other clients who might come to us when these things fail or go a bit south, they might have approached the one lawyer and only one party had the benefit of independent advice. And with that might come some inferences or some allegations of things like undue influence or a lack of independent advice, which can really then subject a testator or a deceased person's estate to costly litigation and also the time consequences that come with that. Another thing I thought I should add there, Danny, as well, is without properly recording these arrangements, which is crucial, as you said, there are a number of presumptions at law. One in particular is between a select or a defined relationship, I should say, such as between spouses. The law can presume that that payment was a gift and not intended to be repaid. So that could be spouses, parents to children. And so it's really important, if that's not the intention, or I guess in all circumstances, that it's deduced to writing and all the nuts and bolts, all those requirements such as interest, as you say, and whether or not it binds an estate is documented.
Another one of those practical considerations is the attorneys and their role to play in things. So often in family relationships, we've got a grandmother whose capacity might come into question, or anyone really where they're acting in the role of an attorney for someone, it creates an extra layer of complexity that needs to be properly considered, and independent advice, as you say, is crucial at that point.
Yeah, that's exactly right, Danny, and especially in these circumstances where we have a principal who is wanting to gift something to an attorney. So say a principal parent wanting to give something to their attorney child. In those circumstances, we have a presumption that arrangement was brought about by undue influence on the part of the attorney child. And so if that gift was ever brought into question, and particularly we see this after the death of a principal, the attorney is going to have the onus on proving otherwise. And so if we've got this sort of situation of a gift between principal and attorney, or even if there's not an active power of attorney, but say the gifter is of advanced age or under some other disability, or even there might be an allegation of incapacity, then it would be really prudent for the gift giver especially to protect the integrity of that gift by obtaining medical evidence or a medical report that speaks to their understanding of the nature and effect of that gift or transaction.
Okay, so moving in a bit of a different direction, we wanted to discuss the importance of engaging a specialist estate planner when you're trying to record these sorts of promises and discussions made. So it's one thing to record a gift or a loan, but it's another to ensure that it works in with your estate plan. So that's especially important when we're considering, the death of one or both of those parties to one of those promises. Whether it be a gift or a loan, the importance of ensuring that your will is taken into account in the recording of those as well. This is particularly relevant where we've got a gift, for example, of, let's use a property, and that is being recorded in one gift document and also recorded in a will that was made however many years ago. The gift under the will has the potential of failing there, which can create issues for family provision applications, beneficiaries being left in the lurch, essentially, where they're expecting one gift under the will and they simply can't receive it because it's been gifted during your lifetime.
Yeah, and in those circumstances, Danny, even if we go even at a lower valued gift, let's just say mum's diamond brooch or something like that, it's quite often at Christmas. I know for myself, going to my nan's house each Christmas, she might say, "Oh, Jess, I really want you to have this pair of pearl earrings." If that gift is recorded in our will, for example, or in my nan's will in this case, and later it's not able to be located, or, she might have given it away to someone else during her lifetime, having forgotten what she told me at Christmas 5 years ago or something like that, there is a risk that that gift will fail, or in this circumstance, it certainly will fail. And what that means is the beneficiary under the will, who was otherwise left the earrings or whatever jewellery in question, actually won't be entitled to a substitute or an equivalent asset. So that's an important consideration as well. If we are getting into really specific gifts in our estate planning, we need to make sure that we are addressing what can happen in circumstances where that gift goes missing or it stops being in the possession of the testator. And I mean, that can be as simple, and you're probably better equipped here, Danny, but that can be as simple as just making sure, okay, keeping aware of what gifts I've made under my will and making sure if I get rid of that gift, I'm touching base with my solicitors and arranging some updated estate planning.
Absolutely. We do generally recommend pulling out the will to review at least once a year, certainly where you start gifting assets after these sorts of discussions things, having a look at what you've got already in place, whether that needs to be updated, and touching base with your solicitor to see the best way to go about that.
Another Christmas job before everyone breaks on leave or while we're all on annual leave.
Yes. Another thing that can be considered in those wills is the ability to create what we call a hotspot provision. So that's just to say that any of those potentially loans or gifts that you make to family members during your lifetime can be brought into hotspot, which means just considered in the distribution of your estate. So at a very high level, that can be, for example, I've gifted $10,000 to my sister. I would like that $10,000 to be brought into her share of the residue of my estate, for example. So that $10,000 will be considered part of her portion, as opposed to her receiving that $10,000 during my lifetime and also her full share of the residue of my estate. So it's another great tool that can be used to potentially even out the playing field if there's a particularly turbulent family relationship, and just generally keep things equal amongst family members.
And look, moving on, I think, Danni, we can also now speak about some of the consequences that can arise in circumstances where gifts or loans or these arrangements that we're speaking about aren't properly formalised. At a high level, I think it's really important that people are aware that once a deceased person has passed away, they're not available to give evidence on these arrangements. And Danni, moving on, I think it's really important that we speak about the consequences of these sorts of arrangements, these gifts or loans not being properly recorded. Certainly at a high level, it's really important that people understand that the court imposes a really high evidentiary burden on parties wishing to make arguments about arrangements that were made during a person's life. And that's because after death, that person's not here to give their side of the story. You can see, I think, or our listeners can certainly appreciate that will make pursuing any undocumented gifts or arrangements really difficult. And certainly for a testator, that's the last thing we want. Again, that goes to time and cost consequences for our loved ones.
Yes, exactly. We see often those, it comes down to intentions, and when those aren't followed through properly by the correct recording of those promises, gifts, loans, it can be really quite upsetting for family members, as well as, like you say, incredibly costly.
And we've spoken before a number of presumptions. We had that presumption of advancement for a payment made between spouses or parent and child, for example. And likewise with the presumption of incapacity for attorneys. What we also get into is this area in equity known as promissory estoppel. So let's use the example of a family farm. Say mum and dad have had a family farm and they've had 2 children, one of whom has been heavily involved in the business. That's been their entire career. And dad makes the promise over the Christmas table, son, you've done so much for the business. When I die, it's coming to you. In that circumstance, what we often see is that son relies on that promise. He might do away with any further plans for his career. He might have otherwise been deciding, hey, I might go to uni and take up a completely different career outside of the family business or the family farm. A consequence of that, again, in circumstances where the arrangement's not properly recorded, is that the son, if dad's will says otherwise and he perhaps leaves the business equally to 2 brothers, the brother who the promise was made to might have a claim in what we call promissory estoppel. Now, that's a claim in equity. And essentially all the son has to do is make out evidence of the promise, evidence that he relied on that promise, and importantly, that he suffered a detriment. In this case, loss of opportunity, potential financial earnings if he had another job offer on the table, so forth. So that's, again, I know we keep pointing or going back to time and cost consequences. It's unavoidable in litigation. These things all cost money to fight out, and certainly a promissory estoppel claim is incredibly expensive. There's also, and I think we touched on this briefly, possibility for those who are possibly, aggrieved or disappointed with a gift that their sibling might have received in mum's lifetime that they hadn't received an equivalent or something like that. There's also the possibility that aggrieved sibling or aggrieved party might bring a claim or make allegations towards the beneficiary, such as the gift was a product of undue influence or unconscionable conduct. Now, again, this goes back to the importance of recording our arrangements and the importance of also, as we spoke about earlier, getting medical evidence if necessary, if the gifter is of advanced age, independent legal advice, because again, if it's not properly recorded or we don't have proper supporting evidence, it does leave the door ajar for these allegations. Danni, they're both really closely related, undue influence and unconscionable conduct. They both sort of involve allegations, or a relationship, I should say, where there's a power imbalance. But the difference is that undue influence requires proof that the the deceased or the gift giver's will was not just influenced but overborne. We're looking at coercion there really on the part of the recipients. Unconscionable conduct, on the other hand, that focuses on whether the transaction was unconscionable given the nature of the relationship between the parties. And that's, one of the recognised relationships there is a relationship between attorney and principal, as we spoke about earlier. There is a presumption under that Power of Attorney Act that a gift by a principal to an attorney is the product of undue influence. And again, that shifts the onus back on the recipient to rebut that.
So I think in summary, we're very much of the view that any of these arrangements that are discussed over the dinner table over the Christmas period are properly recorded, and that the intentions of both parties are completely clear and laid out properly. We've delved into, I think, some of the consequences of not doing that, but it cannot be expressed enough how important it is to properly record all of these discussions that are had. I know you have a few glasses of wine and you get talking and some promises are made, but these things need to be discussed in detail.
And properly advised.
Yeah.
Both parties, it's important. And that doesn't end with a solicitor's advice. It extends to proper financial and accounting advice. Yeah, that's really important. So make those appointments. I suppose if these promises or these gifts are made over Christmas, I think it's really important while they're fresh in everyone's mind to take the steps to formalise them.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.